Welcome to The Explainer, the show where we cut through all the noise and go straight to the source documents to get the real story.
All right, so today we're diving into one of the most common conflicts in any neighborhood, the classic battle between a homeowners association, the HOA, and one of its residents. It's a power struggle we've all heard about, but when you actually dig into the paperwork, figuring out who's right gets, well, surprisingly complicated. So let's get into it.
I mean, just imagine this for a second. You get a notice telling you that you have to pay thousands of dollars to tear down a part of your own house. And why? So the whole community can get a new coat of paint. This isn't some made-up scenario. This is exactly what happened to an Arizona couple, James and Shawna Larson, and it kicked off a legal fight with some really surprising twists and turns.
And here it is. This is the actual document that started the whole thing, filed back on June 16, 2017. The Larsons formally petitioned the Department of Real Estate, claiming their HOA was about to break its own rules. This single piece of paper officially turned a neighborhood disagreement into a full-blown legal case. Okay, so let's set the scene. Our story takes place at the Tempe Gardens Townhouse Corporation. The association decided it was time for a big project. They were going to make some necessary repairs and repaint all 169 units in the community. Sounds pretty standard, right? But there was a catch. And here's the heart of the issue. The HOA told the Larsons, and somewhere between 50 and 80 other homeowners, that their patio covers had to come down. And not only that, but the homeowners had to foot the bill for the removal and the reinstallation themselves. The letter basically said, if you don't do it, we'll have it done for you, and then we'll charge you for it. While the Larsons refused, they argued that the HOA had absolutely no authority to make a demand like that. So they took their case to the Office of Administrative Hearings. And at first, it really looked like they had won. On August 25, 2017, the judge just dismissed the case. Her reasoning, and you can see the quote right here, was that the HOA hadn't actually done anything yet. They hadn't removed the patio cover. It was just a threat. And in the eyes of the court, you just can't rule on something that only might happen in the future.
And this brings us to a really key legal idea. It's called a justiciable controversy. You see, for a court to even hear a case, there has to be a real, live problem, not something that's just potential or speculative. So the first judge felt this case just didn't meet that standard, yet. But believe me, this was far from the end of the story.
Just when the Larsons might have been breathing a sigh of relief, the whole case took a super dramatic turn. A higher authority, the Arizona Real Estate Commissioner, took a look at that dismissal and came to a very different conclusion.
Just look at this. This order is dated August 31st. That's only 6 days after the case was thrown out. The commissioner, Judy Lowe, completely rejected the judge's recommendation. She declared that the dispute was, in fact, very real and ready to be heard. And she ordered the case to be rescheduled for a full hearing. The fight was back on.
This is just a perfect illustration of the legal tug-of-war that was going on. On one side, you've got the judge saying the whole issue is speculative. It's a problem for the future. But on the other side, you have the commissioner saying, nope, it's ripe for adjudication, meaning this threat is real enough that it needs a legal resolution right now. That fundamental disagreement is what sent this case back to court for a final showdown. All right, so this brings us to the main event, the final hearing. On November 20th, 2017, both the Larsons and the HOA finally got their day in court to present their arguments in front of a brand new judge. This was it, their chance to lay everything out on the table.
So what's really fascinating here is how this breaks down the conflict. The Larsons' argument was simple. The HOA just doesn't have the legal authority to make this demand, and the cost is totally unreasonable. They even offered to just paint their own section to solve the problem. But the HOA fired back, saying their governing documents, the CC&Rs, gave them all the authority they needed for necessary upkeep. They argued that removing the patios was critical for worker safety and access, plus you needed one single painter for the whole project to get a warranty.
And then there was the money. This was a huge point of contention. The HOA's project manager basically testified that the job of taking down and putting back up the Larsons' wood patio cover could be done for about $1,000. But the Larsons? They came prepared with two professional bids of their own, one for nearly $4,000 and another for almost $6,000. That massive gap really shows you just how far apart these two sides were. So after hearing all this testimony about safety and warranties and these wildly different cost estimates, the new judge, Thomas Shedden, had to make the final call. I mean, how do you even begin to sort through all these competing claims? Well, his decision came down to a really clear three-step logic. First, he asked, is the HOA's plan even reasonable? Second, does the HOA actually have the authority to pull it off? And third, who is on the hook for the bill? Let's walk through each one.
Okay, first up, reasonableness. The judge actually found the testimony from the HOA's project manager pretty credible. The manager explained that taking down the covers was the only way to repair damaged siding, make sure workers were safe with proper scaffolding, and get that all-important warranty for the paint job. So based on all that, the judge ruled the HOA's plan wasn't just some arbitrary demand, it was reasonable.
Next, authority. Did the HOA really have the power to do this? The judge pointed straight to Sections 9 and 9b of the community's own governing documents. They basically state the HOA can take any cooperative action necessary or appropriate for exterior maintenance. And that word, necessary, well, that was the key. It granted the HOA the authority it needed.
And now for the final and most expensive question, who pays? Well, the answer hinged on another legal term, something called a limited common element. Basically, this is something that's part of the common property, but it's for the exclusive use of just one owner. And the judge decided the Larsons patio cover fit this definition perfectly.
And this is it, the final word from the ruling on December 11, 2017. Because the patio cover was a limited common element, the judge concluded that under Arizona state law, any cost that comes with it falls on the unit owner it's assigned to. The Larsons would have to pay the full cost. The case was dismissed, but this time in favor of the HOA.
Wow! So this one dispute over a single patio cover in Arizona actually has some pretty major lessons for anyone who lives in a planned community or has an HOA. So let's break down the key takeaways from this whole saga. So what can we all learn from this? Number one, those CC&Rs you get in a giant stack of paper when you buy a house? Yeah, they're a binding contract. Read them. Two, an HOA's power often comes down to that squishy word, reasonable. Three, state laws are a huge deal, especially when it comes to who pays for what. That leads to the big one. Know what a limited common element is. If your patio or balcony or front porch fits that description, you're probably on the hook for its costs. And finally, as the Larsons roller coaster case shows us, an early win in court does not always mean the fight is over.
And that really leaves us with one final thought. This whole case shows how an HOA's duty to maintain the community can slam right into a homeowner's rights and their bank account. It all came down to a single word in the contract, necessary. So the question for you is, where do you think that line should be drawn?